Hi, welcome to Rainy City.
Murders, yeah.
Yep,
Episode 5.
episode 5. We are doing pretty good.
Yeah, I'm enjoying this.
So, Rainy City covers the Pacific Northwest, mostly Washington, and we cover everything from mass murder to just murder solved, unsolved, uh, missing,
Mm-hmm.
disappears. We cover the
Mm-hmm.
gamut.
Yep.
Who are we doing today?
So you actually gave me this person indirectly.
Okay.
So she was going through cases and wrote down this name, and it ended up not being the case she wanted, but it
Okay.
gave me a case. It is
Okay.
Seth Frankel.
Okay.
So we are going to 2010.
Okay.
Mind you, this case had developments as recently as 2023.
Okay.
So if halfway through the video we change clothes or hairstyles, it's because we had to cut filming to finish a different day because this case is long. There is a lot of legality and legal jargon, so you might have a lot of questions.
Yes.
So I'm taking you down the hill to D Street,
Really?
right here in
Okay. So
Auburn.
we live up on a hill
In Auburn.
above Auburn, which is Auburn, Washington. We've talked about it. Population of what, 100,000 we've decided, or 70,000?
Okay, the last I looked at that sign, which was years ago, it was like 79,000, but I
Yeah,
know it's updated
it's
since then.
updated. So what we do is we have hills around downtown Auburn.
Around the
There's the
valley.
West Hill, there's Muckleshoot, there's Lee Hill, there's the
Lakeland Hills.
Lakeland Hills, and then there's downtown Auburn,
which is called the Valley.
Yes. So D Street is
Right
downtown Auburn.
Right below us,
Yes.
right across the Green River. So I'm
Yes.
taking you 2010 to D Street.
Okay.
So we have Seth Frankel.
Okay.
He is a divorced father of 2 young girls. He had been living in Auburn for about 8 months before he was killed. This is solved, by the way.
Okay.
It did take a minute to solve, but it is solved.
Okay.
So on May 21st, 2010, 41-year-old Seth Frankel was found dead in his home here in Auburn.
Okay.
He had failed to answer his phone that morning, which led to his girlfriend calling his landlord for a wellness check.
Okay.
So I actually looked up the place. It's very kind of interesting. It's not exactly like houses. It's like apartments, but they're houses. It's kind of
like townhouses.
It's kind of closely resemble townhouses, but not exactly townhouses.
Okay.
So the landlord called one of the neighbors. So the reason I call it's weird is that they do refer to as apartments, but it's not apartments because on D Street there's not apartments.
No, they're like townhomes.
They're not townhomes.
Yeah.
But they're not like Section 8 housing, but it's kind of like
right
in between. It's very weird.
Okay.
So a neighbor knocked on the door of his apartment. So yeah, we're looking at like 100 block of D Northwest.
Okay.
And that is near West Auburn High School.
Okay.
So we're talking, so it's on that back road. West Auburn, here's their house. It's like diagonal.
Kind of like the
yeah. So West Auburn, if you don't know, it is a
alternative high school.
It's an alternative high school.
Yeah, and it's our alternative high school.
So the neighbor looked through the window after knocking and didn't get a response. He called 911 upon seeing Frankel's body. So that was on Saturday.
Okay.
Cut to Thursday, and the King County Medical Examiner's Office released their findings.
Okay.
Which is
4 days.
Which is kind of unusual because King County actually doesn't go that quickly usually.
Yeah.
But
yeah, it does. Depends what year.
Yeah, you would know.
Yes.
You would know. So his death was ruled a homicide once they determined that he died from stab wounds to his neck and hand.
Okay. So, wouldn't they know that if there was a lot of blood or it was back in 2010?
there is a reason to this.
Okay.
So there was not much information between, so he died in May, I said.
I think so.
May.
Yeah.
So there was actually not a whole lot done between May and the summer. So we'll get into this. So Seth was a employee of Kent. He was a successful videographer. He was the city's TV 21 program coordinator who had recently won a first place award at the annual Northwest Video Awards for a film called A Game of Life, which followed a group of high school students as they plan and create a mural, which actually I have seen this film.
Okay.
It's a really good, it's nice. It's a good film. It's a good independent film.
Okay.
So we're jumping to August 2010. And Auburn police were still investigating. They had been waiting on lab results from the Washington State Patrol Crime Lab. And for anyone who does not know, that crime lab is one of the slowest because it's our main crime lab here in Washington.
Yes.
I had 2 professors who worked in that lab, and that was something they always mentioned whenever they discussed careers with interested students, was that time moved very slowly in that lab.
Yes.
And so this did stall the case for a while.
Okay.
So the results they were waiting on were from items they had removed from a person of interest home in late June.
Okay.
The person of interest was a man from Portland, Oregon, and the police had said they did not know when to expect the results.
Okay. Now, it's not like DNA where they get it like TV and then they have it the next day or they have it in 5 hours. Doesn't work that way, people.
Mm-hmm. So Auburn Police Sergeant David Colglazer explained at the time, saying, "We are still waiting for lab results to confirm things. It's hard to say. It's not a quick turnaround. The number of cases handled by the state crime lab is huge. That is our top priority and on our front burner. But when you work with the state labs and private labs, you wait your turn. That's what we have to deal with. They have other stuff they have to work on."
Yeah, the FBI lab is supposed to be better and faster, but they only take so many.
They only take certain cases.
Yes.
For them to take a homicide case, it has to be connected to like potential serial case. There's a whole lot of criteria.
Yeah, it has to be like a child. They're
even
not.
Even then, it's hard.
Yeah, it's.
So they needed these results to give them enough evidence and probable cause to make an arrest.
Yes.
So King County prosecutors had told them they needed more evidence to arrest the man from Portland despite... So I mentioned this on Grim Geography. When we were discussing pinging cell phones and everything, this actually has to do with this, how strict cell phone laws are. Yes. When it comes to police. So they had cell phone records indicating that they showed this man in the area of Frankel's home the day he was killed. Okay. So detectives at this point had not ruled out the possibility of multiple people being involved. This would also, and so this evidence would also be determined by the results of this.
Yes, whether it was just 1 or 2 or more.
So 6 months. In the 6 months following his murder, there was nothing but unanswered questions. The most important being who and why. So, cut to November. So we're in November.
November of 2010.
Uh-huh.
Okay.
And there were still no results from the crime lab.
Yeah, that's 6 months.
His neighbors all wished they had heard or seen something that night. Neighbors only had good things to say about Seth and his girlfriend. They were quiet compared to previous residents, and Seth always had a friendly wave or smile for his neighbors. One neighbor, Steve Tyler, commented saying that they hadn't seen or heard anything since that day, nothing, noting the lack of interaction with the police. So
they are getting no questions. They are getting nothing.
Except for that day that they found
that he died.
Yes. Okay. So going back to the lab results. The police were waiting on examination on the stuff gathered from the Portland house, but also the evidence gathered from Seth Frankel's home. Okay. So Colglazer once again reminded the public it's a priority for the Auburn police, but not necessarily a priority with the state crime lab. But with a homicide scene There are quite a few items to take and a lot of items to check. But the lack of information, especially whether or not Seth knew his assailant, and made them scared to be in that neighborhood. Because they don't know if this is random, if he knew the person. They don't know if they
needed... he'd only moved there a few months before.
He only lived there for 8 months.
Yeah.
They don't know if they needed to be scared. This was children, high school students. This was everybody. So, and after that 6 months, they were just trying to return to their regular schedules.
Yes.
So, December 10th, 7 months after Seth was murdered, an arrest was finally made.
Okay.
So, Auburn Police Department major crime detectives, with the help of the U.S. Marshal Service, arrested a 30-year-old Portland man in connection.
Okay. So this is the man they suspected all the way back in the beginning.
Yes.
Okay.
And we'll get into why, because there's actually is a connection.
Okay.
So
where did he move from? Where did Seth move from?
He lived in Kent, for all I know.
Okay. So he didn't move from Portland.
Not that I believe he did live in Portland for a period, and I believe I have information on that. So the King County Prosecutor's Office charged William L. Phillip Jr. with 1 count of first-degree murder. He was held on $1 million bail while he awaited extradition to Washington.
Okay, so he was living in Portland.
Yes.
So,
we had to extradite him.
Okay.
After this arrest, information started coming out via detective accounts and the charging papers in the courts.
Okay.
So a lot of this information, so this case took me forever because I had to read through charging papers, court documents, affidavits.
Okay.
And that's also why this case will take so long to explain.
Okay.
So we learned that it was estimated that Seth died at 9 p.m. on May 21st.
Okay.
So emergency personnel broke in and found him lying on the floor of the living room, his feet 2 or 3 feet inside the threshold, covered in blood.
Okay.
So if he was covered in that much blood, they didn't initially know what killed him.
Yeah, what killed him.
What stab wound killed him. So crime scene personnel found obvious signs of a struggle in the living room with significant blood present. Detectives noticed 2 black cable ties, the first around Seth's upper right arm and the second lying on the floor under an overturned coffee table.
Okay.
Interesting enough, a motive was not clear during the investigation, at least to the public.
Okay.
So they kept a lot of this under wraps. So
well, of course, because they want to be able to say to the killer, how did you know that it wasn't released?
So despite that, police had a theory.
Okay.
So this comes from Auburn Police Detective Jason Blake's account.
Okay.
So this shedded light on this theory. He recalled how neighbors couldn't understand how someone could kill Seth because he was sweet, kind, caring, etc.
Yeah.
That was not the case for everyone. So according to Blake's account, the only one known to have had a negative opinion was Philip Jr.
Okay.
Who had dated Seth's girlfriend a few years earlier.
Oh no.
He was reported to have been unhappy when she ended her relationship with him to date Seth, with whom she had previously been involved.
Okay. So she had dated Seth. They broke up. She dated Phillips. They broke up and she went back to Seth, right? Okay.
The 2 men had never met. But Philip Jr., who wanted his old girlfriend back, kept badmouthing Seth as old and ugly.
How old was he? 40-something?
41.
Okay.
Seth was 41.
Okay.
So continuing from his account, when detectives from the Portland Police Homicide Unit went to Philip Jr.'s apartment on May 25th, he asked for an attorney immediately.
I bet he did.
They asked for this attorney immediately after they asked if he had ever been to Auburn. 3 days later, Auburn police detectives interviewed him at his residence. Detectives noticed bruising on the fingers of his right hand and a band-aid covering the webbing between between the thumb and index finger on the same hand. Philip Jr. claimed he had injured his hand while working at the Oregon Convention Center. Detectives did find this to be true. However, a co-worker told detectives that he did not sustain any open cuts, nor did his hand bleed as a result of that injury.
Okay.
His supervisors also mentioned that he had access to cable ties at the convention center of the same type, size, and color as the cable ties found at the murder scene. So a search warrant was served on AT&T. AT&T is
It's
phone
a phone company.
To obtain cell phone records that show that Philip Jr. had used his cell phone in Auburn at 7:57 p.m. and 8:52 p.m. on the night of the murder, and that the tower his cell phone used was less than half a mile from the murder scene.
Okay, you guys, if you're gonna commit a murder,
leave your phone at home.
Leave your phone at home. Don't even buy a burner, because they'll get a picture of you buying the burner, and they'll get the serial number and they'll ping it. Okay? We're not trying to help you commit a murder, but I'm just telling you, leave your cell phone at home.
And the cell phone does come back into play, and this does all come back in.
Yes.
So according to Blake, Philip Jr. made a phone call at 8:52 p.m., which began using one tower and then ended at another. The time frame coincided with the estimated time of the murder. So, while processing his mother's vehicle, which he used in May, he used his own mother's vehicle to do this.
Oh my God.
Detectives found trace amounts of blood on the dash and inside the driver's door, but the samples were too meager to obtain a DNA profile from them.
Okay. Do you guys realize that most have a computer inside the car with GPS that they can download? So don't rent a car. Don't take your car if it's newer.
Don't own a Tesla. Don't do it with the Tesla.
Yeah, it'll take them right to you.
However, despite the not being able to get a DNA profile, they were later able to match that blood stain at the murder scene with Philip Jr. So this arrest, of course, relieved so many people.
Oh yeah.
Neighbors, co-workers, friends, and family. So Richard Frankel, Seth's father, said that it finally provided some closure. He praised the Auburn Police Department and thanked them for keeping him updated where they could. He said, "I do not want to say it brought happiness. These have not been happy times, but I do find relief that he is off the street and cannot try to harm anyone else in the family. My wife, Seth's stepmom, was very nervous. This is a sense of relief. It's frustrating that Seth is dead and this guy is going on with his job and his life. There is some satisfaction with an arrest, but it's not like we were doing any high fives and partying."
No.
So they got his arrest in December.
Yeah.
December 2010. They went to trial near the end of 2013.
Okay, so that's 3 years.
So, and I couldn't find any reports on what happened during the trial. Only what happened at the end. Do you want to take a guess on the outcome of this trial?
Hung jury.
Hmm.
He was acquitted?
King County Superior Court Judge Andrea Darvis declared a mistrial on December 18th when the jury was deadlocked. The jury was deadlocked at around 1:45 p.m. Wednesday after going into deliberations Tuesday afternoon.
So they only deliberated a few hours?
Mm-hmm.
Oh my God. I mean, usually those judges make you do it for 3 or 4 days before they...
So a review hearing was then scheduled for that Friday in front of Darvis to determine when and if Philip Jr. would be retried. The trial this trial had lasted 6 weeks.
They're going to retry it.
Wyman Yip, he was a senior deputy prosecutor, portrayed Philip Jr. as a man who wanted to return to a romantic relationship with Johnson, that's Seth's girlfriend.
Yeah.
And went so far as to kill Frankel in an effort to get back with her. Yip said the evidence of a towel found near the murder scene with the DNA of Philip's cell phone records and text messages proved that he committed the crime.
Okay.
So his defense attorney, Philip Jr.'s defense attorney, painted a very different picture, of course. She told the jury that the state was quote unquote trying to put a square peg in a round hole by blaming Philip Jr. for the murder. She said, "Not a single witness can put Mr. Philip in Mr. Frankel's house on the night Mr. Frankel was killed. Not a single witness can tell you that Mr. Philip knew where Mr. Frankel lived or worked or even knew his last name. Not a single witness can give you a reason why Mr. Philip would kill Mr. Frankel."
Well, I can tell you why. The girlfriend.
So she concluded that the state charged the wrong person simply because Philip couldn't be excluded from being in Auburn the night Frankel was killed. She said Auburn police failed to investigate other people who may have committed the murder.
Okay.
So
this is 2013. Okay, so this is 3 years later.
So Judge Jarvis decided at the hearing that Philip Jr. would face a second trial. There was a lot of buzz from all sides of this trial.
Okay.
So, saying that Patrick Hines, another deputy prosecutor, said it's obviously always disappointing to have a trial of that length and to not have an outcome and have to do it all over again. He went on to say the mistrial came as a disappointment for Seth's family as well. His father Richard traveled from his home in Hawaii, and his mother Emily traveled from her home in Virginia to attend each day of the trial. So, after this, Hines said, after this long between the date of Seth's murder and the trial, and the length
is he out on bail?
We'll get into all that.
Okay.
And the length of the trial, they were looking forward to having some closure one way or another. It puts it off for longer either way. They were disappointed with that, but they understood that this is one of the things that happens when you have a jury system. It needs to be unanimous to convict, unanimous to acquit, and anything in between, you keep going. I think they understand that. So, the new trial began in 2014 and ended in April. It lasted as long as the first one, but the outcome was different.
Okay.
He was found guilty. So, trial ended in April. He was sentenced in June 2014. He faced 20 to 26 years for stabbing Seth Frankel.
Only 20 to 26?
Prosecutors wanted 26 years, defense wanted 20. Jurors from both trials attended the sentencing along with relatives and friends of both Frankel and Philip.
Okay.
Saying Judge Jarvis, before issuing the sentence, said this was a violent and senseless crime. So one of the jurors, Bonnie Weymouth, told reporters after the sentencing on what convicted her to vote guilty, saying that the evidence was the DNA in Seth's apartment that only could have gotten there with Philip being there, and the cell phone that traced him where he was all that day and when he was there. That's the two pieces of evidence I needed in my heart to put it all together. So, Philip Jr. opted to not make a statement. He was sentenced to 25 years. So what are your thoughts?
Why didn't he get life in prison?
Maybe
it's just not the way it was, but I
guess because it went to county court instead of state.
Yeah. I don't know. He should have gotten life in prison.
So what if I told you that this is not where this case ended?
Oh, God.
2016. This ended up going through several appeals in the Court of Appeals in Washington State. This case brought forward a debate that was only the beginning.
Okay.
So I will get more into that after I go through the first appeal.
Okay.
This was filed on August 29, 2016. So this is 6 years after the murder.
Yes.
2 years after he's been sentenced.
Yes.
So and this was sent as an unpublished opinion, which is important to know because a published one never made it to the public.
Okay.
To make it simple, Philip Jr. wanted his sentence overturned and the phone records to be thrown out.
Okay.
So a search warrant may only issue if the underlying affidavit provides facts and circumstances sufficient to conclude that the defendant is probably involved in criminal activity and that evidence of the criminal activity is likely to be found in the place to be searched. So while a magistrate may draw reasonable inferences from facts in the affidavit, mere speculation is not sufficient to give rise to probable cause. So in this case, William Philip Jr. challenges the trial court's denial of his motion to suppress, arguing that the warrant authorizing search of the phone records was invalid.
Yeah, we're going back to the phone records. I mean, now it's really easy to get the phone records, but back then it
No,
wasn't.
even now it's still a hot debate
Yeah, it is a
because
hot debate.
and and it depends on the court now.
Yes, it also depends on whether your phone number is appearing on the original ones and they have to go
But
back and find out.
and then it also means that they also have to have probable cause
Cause,
and not enough probable cause to even get the records.
okay, so what did they do with this one?
Agreed with him.
No.
And like I said, this is dragged on to 2023 and we're still waiting on an outcome in that one. I'm talking like this went all the way to
He's turning a lot of pages, people.
this went all the way to the Supreme Court
Of Washington or Supreme Court?
I think
of
both.
Wow.
And we're still waiting to hear back on the 2023 decision because I couldn't find anything about it or if he's challenged it again or
Yeah.
Yeah, you'll probably see us in new clothing because we have to continue this tomorrow.
We're gonna
Because, like I said, this is
tomorrow.
like 20 pages of stuff I had to go through.
Yeah, there's a lot of stuff. So that's just the
That's just the case.
That's just the case, and that's the first appeal.
Mm-hmm.
So we will.
I promise before we get to the very end, I will re-summarize it because
yeah,
there's so much legal jargon in this that you're gonna have so many questions.
Yes.
I'm not even kidding.
Okay, so we'll say goodbye for right now,
Yep,
but we've got tons of stuff.
We'll be back tomorrow.
Yes, we will. Okay, bye.
And we're back.
Yes, we are. We had to stop yesterday because we had things we had to do. So we're back today to finish it. As you can see, the new clothes.
Except for me. Mine's really easy though because it's just a jacket.
Yes. So she wears her jacket.
We're discussing the murder of Seth Frankel.
Yes.
So we left off at the 2016 appeals.
Yes. Where
they challenged the cell phone records.
Yes. And we were talking about how cell phone records are kind of
a gray area that they're still trying to figure out, but it's a very hot button debate.
Yeah. I mean, I guess now if a murder victim has contact with somebody, then they get the cell phone records to figure out who the other person is.
They still don't. Look what happened with Gabby.
Yes.
How hard it was for them to get cell phone records.
Yes.
So it's actually not that easy because there's so much that goes behind it, and we'll get into that. I actually have that research, some of that research.
Okay.
So 2016, they challenged the cell phone records.
Okay.
And they essentially a little bit sided with Philip Jr. They told the state to go back and amend everything.
Okay.
William Phillips Jr., who went on trial for his murder, he was Frankel's girlfriend's ex-boyfriend.
Yes.
So
that wanted her back.
Yes, and said that Frankel was ugly and old.
Yes.
Let's get that right.
Yes.
So
he was 41.
Yeah, Frankel was only 41.
Yeah, I would hate to see what he thought of me.
Philip's side, argue that the cell phone records were invalid.
Yes.
The state went back and they kind of hemming and hawed, and then they're just like, okay, they can stay in, but the state has to amend some of the charging papers.
Okay.
The decision came out. His side was not thrilled because he was still in jail.
Yes.
So cut to 3 years later, 2019.
Okay, so we're in 2019. And all this happened in 2010?
Yeah.
Okay.
They once again filed and argued about the cell phone records. That is what all of these appeals are about, is the cell phone records.
Okay.
So
because the cell phone records showed him being there.
Mm-hmm.
Well, supposedly. You know, I don't know how to read cell phone records, but I'm assuming if it's admitted to court that it has to be pretty accurate.
It pinged off the towers within the area and the time that the murder occurred, so.
Yes.
So they filed these charges, they filed these affidavits again using essentially the same arguments.
Okay.
So I'm going to go over the opening again.
Okay.
I have the full opening, and then we'll go over the highlights of the response.
Okay.
So they said, in the digital age that we live in, cell phones are now a pervasive and instant part of daily life. Advent of this new technology comes the potential for its abuse. Cell phone data, for example, represents a new frontier in police investigation tactics. Cell site location information, so it's called CSLI, and this is the main issue is CSLI.
Okay.
So this is what is always debated in every case that deals with cell phone records.
Okay, but this is what they said about DNA.
But look how long it took them for DNA to become usable in court and all
yes.
that. So it is a highly detailed data which can create a historical map on where a particular cell phone traveled during a set period of time. Based on this technology, police are able to look back in time and find out precisely where anyone was at a given time.
I told you, leave your cell phone at home. If you're going to commit a crime, leave your cell phone at home.
But this also comes on the behalf of only by the retention policy of the individual's wireless provider. So every provider, whether it's Apple, Google, AT&T, T-Mobile, Sprint,
Comcast,
Xfinity, Mint, they all have guidelines designated by the FAA? FCC, thank you. By the FCC, but then they also have their own within that. So there's certain things that can't be done on certain phones. So
yeah,
like on Apple,
some are smartphones, some
Well, like on Apple phones, when you Apple does not allow for people who are on parole and need monitoring technology on their phone to monitor what they're doing on their phone if they're violating their probation, their parole, whatever. Apple doesn't allow it. There's a certain thing you have to go into, certain agreements and certain stuff you have to actually bypass to be able to do it.
Okay.
So that's why it is usually done on like Samsung.
Okay.
Or their smartphones. But Apple has these policies in place to protect the user. And they are so in depth that they can lock you up in a court for like years.
Okay.
And we're not getting into how I know that.
Yes.
So the protection against abuse of this highly detailed and personal information is through a familiar mechanism, the constitutional requirements of a warrant. So a warrant, supported by probable cause and meeting the particular requirement, provides an individual with the constitutionally required protections against privacy invasions by the state.
Okay.
So William Phillips sought a discretionary review of a trial court order approving a subpoena issued to Phillips' wireless provider, requiring the provider to release Phillips' CSLI records. Because the state failed to seek issue of a warrant, and state and trial court failed to recognize Phillips' privacy interest in the CSLI records, we reverse, vacate the subpoena, and remand for further proceedings.
Okay.
So this also goes into
and they needed the cell phone records to prove that he wasn't in Portland, that he was here.
Because without it, they only had the blood to go off of, which
is fine. I mean,
but it's still very circumstantial, and it was potential that they couldn't win because most of the jurors said it was the blood, but it was the cell phone records that made them go guilty.
Yes.
So this affidavit also goes into the facts of the case, which they hadn't changed.
Okay.
So it's the same what we've already gone over. So on appeal, we conclude that the facts in the affidavits used to obtain the May 2010 and March 2012 warrants for Phillips' CSLI records failed to provide a sufficient factual basis for which to infer that evidence of the crime would likely be found on Phillips' CSLI records. So essentially what they're saying is that they did a subpoena, but there was no warrants.
Okay.
And
So
that the
that is kind of the gray area.
and so they did so essentially they did get warrants, but they did not have enough factual basis
For the warrant.
for the warrants. There was
Okay.
not enough probable cause.
Okay.
Essentially, this brought forth a question basically to what extent of privacy is someone allotted in regards to your phone.
Okay. This is 2019.
Yes,
Okay.
but this is dating back though to 2010.
Okay.
So
back then there were different.
the smartphones aren't what they are right now.
Yeah.
But the question is, what extent of privacy are you allotted when it comes to your phone? Because your daily life is right there in your phone.
Yes. But
So
you see all those shows, where they say, "Can I have your phone?" and the idiot turns over their phone.
Mm-hmm. But we've seen in so many cases how hard it was for police to access a phone, and most of those cases have shown how quickly they could have been solved if police had immediate access to the phones.
Yes.
So, but the thing is like we've seen it again with Gabby's case, we saw it with the Boston Marathon bombers. We've seen it with a lot of really big cases, how quickly they actually could have been solved if police
had the phones.
But all these companies back then, yeah, they would give them kind of based off of a lackluster subpoena and lackluster warrants. But now, so much has changed, so much privacy.
Yes.
So at this point, a lot has happened in this case since it started.
Okay. So we've gone from 2010 to 2019, and it's been appealed again.
So we got hung jury. Then a jury eventually convicted him of murder, but on appeal, the Court of Appeals reversed Phillips' conviction. The court ruled that the warrant for Phillips' CSLI records were not supported by probable cause. In other words, police didn't have enough evidence at that point in the investigation to justify the warrant.
Okay.
So, but that did not stop the state. They changed tactics.
Okay.
The CSLI records were crucial to the government, crucial to our state's case.
Yes.
So the state asked the trial court to issue a subpoena to get Phillips' CSLI records from AT&T. A judge granted it, and then Phillips appealed and won once again.
Okay. So was this 2019, or have we gone on farther?
This is still this time period.
Okay.
Something to keep in mind about the laws here is that in the state so in Washington State.
Okay.
So in our state constitution is more defendant friendly than the defendant willing Fourth Amendment, because this is kind of what comes in. It is the First Amendment, but it's also the Fourth Amendment. But our state constitution is more on the defendant's side.
Yes.
So here in Washington, your privacy rights are held in high regards. Unless law enforcement obtains a warrant, they cannot disturb your private affairs. If they don't, and they find evidence that supports your guilt, they can't use this evidence against you at trial.
Okay.
This is the exclusionary rule, one of the most defendant-friendly provisions in all of criminal law.
Okay.
So that's why Philip keeps winning his appeals.
Okay.
So in granting the state's subpoena, Phillips' trial judge determined that he had a lower expectation of privacy in cell phone towers than he did in, for example, his personal cell phone or his apartment. Therefore, the state didn't need to get a warrant, and the court disagreed.
Okay.
So, but this also comes into this thing, is that we also extradited him from Portland.
Okay.
So he is technically an Oregon citizen.
Yes.
So
Portland, Oregon, not Washington.
So he is an Oregon citizen. So here comes the issue is we also have to treat him by that laws, but we also have to do it under ours.
Yes.
So today, CSLI records provide an intimate window into a person's life. If you go to church, your cell phone knows it. If you go visit a strip club, your cell phone knows it.
Yes.
When you visit your family, your cell phone data shows that. So as the court put it, what could be more intimate and private than your personal, sexual, or religious preferences?
Yes.
So for these reasons, individuals have a reasonable expectation in the privacy of their physical movements. So they have a reasonable expectation of privacy in their cell phones and
Okay.
in their CSLI records. And because you have a reasonable expectation of privacy in your cell phone records, police need to get a warrant. The government can't circumvent the warrant requirements by applying for a subpoena.
Okay. So this is still 2019,
So that's a little more background into
okay.
what the privacy laws are at the time.
Okay.
So Court of Appeals said no and told the state to figure it out. So to use his CSLI records at trial, the state would have to prepare a more detailed warrant application or go forward without them.
Okay. So, but do they have DNA? Which
they have his blood. They had his blood at the scene.
A lot of people will convict on DNA.
But it was a minuscule amount.
Yes.
So that is an issue.
But the guy said he had never been. He didn't know where the guy lived.
So it kind of is. It's that weird back and forth.
Yes.
But also his defense attorney was a shark.
Yeah. Don't leave your DNA. And don't take your cell phone.
So the court emphasized the significant role of cell phones in daily life and their potential for misuse in police investigations. Particularly regarding cell phone site location information. So this can create, it's the map. It's a historical map. And so raising privacy concerns that require constitutional protections, specifically the necessity of a warrant based on probable cause. William Phillip sought discretionary review after a court approved a subpoena without a warrant.
Okay.
So the state did not. So as we said, they didn't recognize it. They vacated the subpoena, remanding for further proceedings.
Okay, but he wasn't out of jail. He was in jail the whole time. Okay, so they hadn't let him out on bail. And what was the girlfriend saying at this point?
So I have that.
Okay.
So a lot of the information were not on the charging papers. A lot of these court records were sealed. So a lot of this did not come out until he went to the appeals court, because these have to be made public unless it's like a minor.
Okay.
And even then, like there's a gray area.
Okay.
And Washington does recognize the freedom of the press releases and everything, but it's hard to get.
Yes.
So his girlfriend,
ex-girlfriend.
No, Seth Frankel's girlfriend.
Oh, yes.
So after she couldn't reach him, subsequent police investigations revealed that Phillips Jr. and Johnson were in frequent contact through phone records, and the police obtained 5 warrants, including one for Phillips's CSLI records, without initially disclosing the murder investigation to him. So the girlfriend and him were in contact. But so when they served the search warrants at his property and all that, they never informed him that he was under investigation for the murder, which is a big no-no in criminal investigation.
Wow. And where was this girlfriend this whole time?
His girlfriend had been out of town, apparently. She had been working in Oregon.
Was she ever charged?
No. Because as they saw, she was the concerned girlfriend. She's the one who called to get and jump-started all this, technically.
Okay.
So, and there's nothing to prove. And even if they were having an affair, she didn't commit murder.
No.
She didn't do anything.
Nope. But she could have been the catalyst.
Mm-hmm.
But I assume she just broke up with him.
Yeah. So you got the workplace where a supervisor, noticed his frequent use of zip ties, the ones that matched the ones that they found at Frankel's house. You got June 20th, 2010. They obtained his CSLI from AT&T, indicated he did travel from Portland to Auburn on the day of the murder, remaining near Frankel's house until 9 p.m.
Okay.
So, search warrant executed. Like I said, a lot of this didn't come out until the 2019 appeals.
Okay.
So you have a search warrant executed on June 22nd, 2010, led to the seizure of Phillips' his actual cell phone and journal, revealing his obsession with a woman named Johnson and a negative view of Frankel. Phillips' mother informed police that he
was ugly and old.
Yep. Phillips's mother informed police that he borrowed her car shortly before the murder, which contained traces of blood from the cut on his hand. DNA analysis from the crime scene indicated 2 DNA types, one belonging to Frankel and another from an unknown male, possibly Phillip, with a statistical likelihood of 1 in 2.2 million for his contribution.
Okay.
So, following that result, he was arrested and charged with first-degree murder. So then they did a subsequent warrant on January 25th, 2012, which allowed police to search the contents of his cell phone. So that's why his trial didn't go until 2013, is because they were waiting on that search warrant for his cell phone, his actual physical cell phone.
Okay.
So in March 2012, the prosecutor requested a more detailed warrant for Phillips's CSLI records, which was granted on March 22nd, 2012, after incorporating additional details about the crime and Phillips's relationship with Johnson. So they did everything. And so that is what kind of is the big issue, is that they granted that subpoena without a warrant and then told them that they were allowed to basically write the warrant and backdate it.
Okay.
So, and
can you do that?
Apparently, I guess you can, because this incorporated additional details about the crime and the relationship with Johnson, which they did not have until they arrested him and they seized his cell phone and his journal.
Okay.
So think about it this way. They granted the search of his cell phone in January 2012. 3 months later, in March, they let them write the warrant for his his CSLI records, which they already had via subpoena.
Okay.
So Phillip moved to suppress evidence from the search warrants, but the trial court denied the motion. It found that while the May 2010 warrant lacked probable cause, the March 2012 warrant met the necessary standards, citing the independent source doctrine.
Okay.
So Phillip was ultimately convicted of murder after a retrial. On appeal, the court determined that the affidavits for both May 2010 and March 2012 warrants lacked significant factual basis to support the belief that evidence related to the crime would be found in his records, his CSLI records.
Uh-huh.
So, the March 2012 affidavit details the crime scene, noting locked doors in an untouched apartment except for the area around the body. It includes statements from Johnson asserting that Phillip, who had military experience and was upset after their breakup, was the only person she could think of who had spoken ill of Frankel and might try to harm him. So you had then Phillip in his statement to police describing Johnson as just a friend and invoked his right to counsel regarding his potential presence in Auburn. The affidavit presents flirtatious text messages exchanged between Johnson and Phillips during the week of Frankel's death.
Uh-oh.
In which Philip referred to Frankel as an unhot old man.
Oh my God. We shouldn't even laugh. The guy is dead.
And Johnson, of course, admonished him for the remark. However, the messages do not indicate any intent to harm Seth Frankel.
Okay.
The affidavit suggests a close relationship between Johnson and Phillip, but the evidence only applies possible jealousy on Phillip's part regarding Frankel. It does not establish any reasonable inference of his involvement in Frankel's death or that pertinent evidence would be found in his cell phone records.
Okay.
So Phillip's reluctance to discuss his travels to Auburn did raise questions for police, but did not provide a significant nexus to connect him to the crime.
Okay.
The state positioned that Phillip had motive and access to Frankel's apartment through Johnson, and speculated about a possible conspiracy between them to harm Frankel. However, these assertions are deemed speculative and unsupported by the text messages, where Johnson defends Frankel. Ultimately, the affidavit's lack of concrete evidence led to the conclusion that probable cause was not established, resulting in the reversal of Phillips's conviction and the remand for a subpoena for his cell phone location information records.
Okay, are we still in 2019? Yes. Okay.
Yes. So, like I said, this is a very complicated.
Yeah, it is.
Complicated case. And we're not even halfway done.
We need to move on.
So the state submitted a memorandum instead of a new affidavit to support its subpoena, which included 6 prior affidavits related to Phillips's case. These affidavits consisted of certifications and warrants, some of which referenced the tainted CSLI records deemed insufficient by the trial court.
Okay.
So the state's paper summarized the evidence from these affidavits and argued for a probable cause standard for the subpoena's issuance. However, it incorrectly claimed that a previous decision regarding Phillips established that the state would have pursued cell phone records without the tainted CSLI records.
Okay. So, in other words, even if they didn't have the phone records, they still would have charged him.
Yes.
Okay, based on the DNA.
Yes. So, additionally, the state contended that Phillip lacked a legitimate expectation of privacy in his cell phone records and referenced a prior opinion suggesting that police had probable cause to investigate Phillip prior to obtaining his records.
Okay.
See what I mean? How complicated this is?
Yeah, it's getting kind of boring too. There's way too much information.
We disagreed with the state's interpretation.
Okay.
Reaffirming that the trial court did not err in admitting evidence from the searches of Phillip's apartment, vehicle, and DNA, as these warrants were valid. However, the court found that the trial court erred by denying his motion to suppress his phone records.
Okay.
And the related to the number he dialed, and the CSLI related to the number he dialed on the night of the crime. So leading to a reversal and remand for further proceedings. The court clarified that his previous opinion only supported the warrants for DNA and other searches, not for the records, and criticized the trial court's application of a lower privacy threshold based on the statement's argument that Phillip voluntarily shared his data with the provider.
Okay.
Yeah. So he does, as I said, he has a heightened expectation of privacy in his personal cell phone and apartment compared to like the tower location records. So the state's argument conflicts with the Supreme Court's ruling in Carpenter, which recognizes a reasonable expectation of privacy in cell phones, or probable cause constituting an infringement of his privacy rights. So the state incorrectly contends that a subpoena based on a probable cause standard meets legal requirements under Article 1, Section 7, but the expectation of privacy in CSLI necessitates a warrant.
Okay, is this Washington, our state Supreme Court?
No, this is federal.
This is federal
Supreme Court.
Okay.
Federal Supreme Court has a case, Carpenter. It's a famous case.
Okay.
And then they're just like, no, these people have a reasonable expectation.
So if the cops ask me for my cell phone, I don't have to give it to them?
No, essentially you don't.
Yeah.
Yeah, but we've seen how well that turns out sometimes.
Yeah. Okay. Come on. We can't say it more than enough. Do not take your cell phone if you're going to commit a crime. Leave it at home. And don't take your mother's car. Come on.
So in response to that, the state attempted to differentiate its case from Carpenter, asserting that the Supreme Court did not mandate a warrant in all instances. However, the Supreme Court clearly indicated that without a warrant... We're
talking about federal. Okay.
So, the Supreme Court clearly indicated that without a warrant, the government cannot compel a wireless carrier to release CSLI. The state's reliance on Garcia... So, this is another case. It's Garcia Salgado, which allows a court order to satisfy warrant requirements under certain conditions is misplaced, as this decision predated Carpenter and did not evaluate the implications of that ruling.
Okay.
We're almost to 23. I promise, we're almost.
Okay.
So for a court order to replace a warrant, it must be issued by a neutral magistrate, specifically the search location and items, and be supported by probable cause based on an oath or an affirmation.
Okay.
The state did not provide a new affidavit of probable cause for its subpoena request and failed to connect known facts to the need for Phillips's records. So the trial court granted the subpoena without a specific finding of probable cause. Okay. Compounded by the belief that Phillip had a diminished expectation of privacy, consequently, the court cannot determine if the state met its probable cause obligation. So the subpoena is reversed, vacated, and the case is remanded for further proceedings.
Okay.
So I'm assuming.
His trial wasn't thrown out.
No.
They just had to amend.
So the subpoena was reversed, vacated, and the case is remanded for further proceedings.
Okay.
So essentially, is they told the state, fix your shit, or we're releasing him.
Okay.
So I'm assuming the state fixed what they needed to because he's still in jail.
Okay.
So here we are at 2023.
Okay. No, we're actually in 25, but we're to the year 23.
Yeah. You would think that was the end of it.
Oh, no.
You would be wrong. And we are back in not only the Court of Appeals, but also the Washington State Supreme Court.
Okay.
So the appeals was filed first. So apparently they filed appeals and to the Supreme Court at the same time.
Okay.
About the same time. So we have the prior appeals. 2016, the warrants were thrown out. 2019, courts ruled subpoena used to get was invalid under Carpenter v. United States 2018, since a warrant was required. That's how new that case is. It was 2018.
Yeah.
So that case came out the year before.
Well, we were talking about it being a gray area.
Mm-hmm. So the current appeal, as it stands, because there is no conclusion yet to this.
Okay. Well, it takes a few years. It isn't overnight.
Mm-hmm. So after remand, the state obtained a new 2020 warrant for Phillips' cell phone data. This affidavit relied only on information independent of the CSLI. So we're talking his suspicious hand injury, DNA evidence, zip tie access, his hostile remarks about Seth.
Yes.
So Philip argued the 2020 warrant was invalid because it was tainted by prior illegal searches, overbroad, and based on misrepresentations and omissions. So the court's findings was that the 2020 warrant was valid under the independent source doctrine, even after removing questionable references to statements from Phillips's mother that they may have learned through tainted evidence. Enough untainted facts established probable cause.
Okay.
So police were motivated to pursue Phillips and his phone records independently of the earlier unlawful CSLI search. The warrant was not overbroad. It covered April through May 2010, was reasonable in a homicide investigation.
Okay. So they ruled that what they were looking for was reasonable.
Yes.
Okay.
And that no intentional reckless misstatements in the affidavit undermined probable cause. So arguments about attorney-client privilege had already been resolved in 2016. So that was another thing, is that the use of his cell phone to contact an attorney was in his emails.
Oh,
so
okay.
There's a whole gray area in all this because of this. So the decision was from the Court of Appeals affirmed that the trial court's denial of Phillips's motion to suppress the 2020 CSLI evidence and remanded for further proceedings consistent with this ruling. So Supreme Court. So he wanted the Supreme Court for discretionary review after the Court of Appeals upheld the validity of a 2020 cell phone warrant under the independent source doctrine.
Okay.
He also again raised the issue of attorney-client privilege violations because the police found emails to a lawyer on his phone.
Okay, well, they can't use those against him.
And they didn't.
Yeah.
So the state's was that attorney-client privilege issued should not be revisited because it was already raised in 2016. The Supreme Court denied the review in 2017, making the ruling final. Court rules prohibit reconsideration of a denied review petition, and the issue was not fully briefed in the Court of Appeals this time, only raised late in prose filing, so it's poorly presented.
Okay.
So then you have the independent source doctrine was correctly applied, saying that Washington recognizes the doctrine as consistent with Article 1, Section 7 of the state constitution. And the Court of Appeals correctly asked, did the tainted evidence affect, 1, the magistrate's decision to issue the 2020 warrant, or 2, the police's decision to seek it? And the police had already suspected him early, despite the records. We're almost done.
Okay.
So Phillips' argument for a stricter rule under state law is consistent to precedent. Washington has already adopted federal standard.
Okay. So
the conclusion was the state asked the Supreme Court to deny Phillips' motion for discretionary review. It argues that both that A, the attorney-client privilege issue was already decided years ago, and B, the Court of Appeals applied established independent source doctrine of precedent in upholding the 2020 warrant. So that is where this case is today.
Okay, so
Um,
it
the Supreme Court
is
has
the
not responded.
2025.
So we're 2 years later. The Supreme Court has not responded, and I'm assuming they haven't because he is still in jail.
Yes.
And he has not had a court appearance recently.
No, I would
And
assume. I mean, even if you took the cell phone records away, we're talking about all the other proof.
yes. And also, Washington Supreme Court, as you said, it takes a couple of years for them to
Yes. I
deal
mean,
with
they
everything.
just don't automatically give it
Well,
up.
it's
Even
also
the appeals courts.
but it's also the Supreme Court sessions here are so weird.
Yes.
Like, I feel like they're always in recess whenever I'm trying to look up a case here. It's so weird.
That's right. Get yourself a job on the Supreme Court.
I mean, it makes sense right now because I think we're coming up to the newest election cycle.
Yes, it might be. So this poor man is dead. His girlfriend
may have been having an affair.
Yeah, may have been having an affair with the guy who killed him. But she was defending him, so probably not.
William Phillips Jr. thought he was a unhot, ugly man.
Yes. And he must think he's a hot young man to say that. I don't know what to say to all that.
It's so complicated, and I'm sorry for all the legal jargon, but it's just like I had to read through hundreds of pages of affidavits to get this case, to actually figure out what this case was.
It's crazy. It's absolutely crazy.
And like the fact that it's still being dragged on, I just feel for his family.
I know. It's crazy. The family, what do they do? I mean, okay.
That is what we have.
Okay. So if everybody was bored out of their mind, we're sorry. But we had to cover everything.
Yeah, it's a very gray area, and I'm curious about what a lot of you guys think about it.
Our biggest gray area was the cell phones, and we're trying to cover things besides the murders or the disappearances or stuff that's unsolved. We're trying to add something to it, and this was the cell phones. We wanted to know what you thought about it. So
I'm also putting up a poll with this episode.
Your what?
I might put up a poll with this episode.
Yeah, well, okay. So, okay, sweetheart, I love you.
I know you have to go.
I do. I have to go.
But we shall see you guys next time.
Yes, we will.
Bye.
Bye.